Hi, everyone. I'm Doug Black, Editor-in-Chief at Inside HPC. And today we have with us Gary Marchant. He is a law professor at the Sandra Day O'Connor College of Law at Arizona State University. And Tucson was the location of a recent HPC User Forum hosted by Hyperion Research. And during that conference, Gary gave a really well-received and fascinating presentation on AI and the law, generative AI, and its impact not only on the practice of law, but on laws themselves, or new laws. So we wanted to go through that with Gary. And Gary, welcome. And I was running through your slides from the presentation, and one of them included a very bold statement. It said, "One thing is becoming clear. Lawyers who use AI will replace lawyers who don't." Could you expand a little bit on that statement?
Sure. So a lot of the previous technologies we've seen in law that lawyers are dealing with, there's sort of a practice group that has to learn that and deal with that. This is AI is going to cut across every type of law, every type of practice, and significantly make it more efficient, streamlined, less costly. And so it just won't be possible to continue to not use these tools and be competitive in a very competitive legal marketplace. So basically, anyone who doesn't pick up this technology is quickly going to be priced out of the market because the human labor, manual labor, is just too expensive for many of the tasks that AI can now do very quickly and cheaply.
Okay. Yeah, and as we all know, legal support, legal services are extremely expensive. So everyone is always looking for a way to do it less expensively. Now, you divided your talk into two categories: the impact of AI on the practice of law and on laws. Let's start with the legal industry itself. You had some interesting comments about how large language models are automating and accelerating some legal work and thus reducing billable hours. Can you share some observations in that area?
Sure. So I have a specific example of a lawyer who basically was writing privacy policies for clients. He said it would normally take him 6 or 7 hours to do that. He asked ChatGPT to do it for him for a client, and it produced a privacy policy that was very good. He had to spend 15 minutes just cleaning up a couple parts of it, but now he's got a great privacy policy that took him 15 minutes of his time that would normally take 6 or 7 hours. And the question he asked is, how much should I bill my client? Because I'm out, a lot of money if I just bill 15 minutes, and yet that's all I put into it. So how do I go about billing my client in an industry that's based on the billable hour? So this is going to be the fundamental, I think, threat and challenge for the legal industry of basically moving away from this billable hour, which is an extremely inefficient way of charging things that basically rewards inefficiency. The longer you take as a lawyer, the more you get paid. That's not the right incentive. So for a long time, people realize that's sort of a bad model, but this will now provide the incentive to do that, because if you only can bill 15 minutes, it's not going to, pay the bills for your law firm. So you need to basically now start charging on a per transaction basis. Maybe you'll charge $2,000 for a privacy policy instead of, $6,000 or $7,000 before, or 15 minutes time, which is, a couple $100 most with just pure time. So it's basically going to force the industry to move to a more realistic and better incentivized way of how they bill their clients. It'll save money for clients, and it will also, help make lawyers more efficient and profitable.
Yeah, and certainly that's a huge competitive advantage if you're delivering services at much less cost, because you can be much more efficient. By the way, and in that anecdote that you raised, I'm not sure you closed the loop. What did that lawyer end up?
He didn't say. This was on a social media site, and he didn't say what but I think he would have had to charge just 15 minutes. I mean, I think it would have been unethical, because he had an hourly billing rate with his client, to charge 6 or 7 hours. And so that would have been very unethical to do that. So I think he had to charge 15 minutes, which the client must have loved. And then, the next law firm that basically says, I can do your privacy policy if they're going to bill 6 or 7 hours. They're not going to go back to that law firm, will they? They'll go back to the guy who can do it in 15 minutes. And so that's why the market's going to drive us towards this technology. And lawyers have to figure out how they should restructure the way they currently charge clients in order to be able to capture some of the savings that AI is going to bring to the entire endeavor.
So firms that are adopting generative AI, large language model technology, what are they doing? Are they feeding curated data sets with legal precedent, legal documents into a large language model and then running results that way, or are they just using sort of a generally accessible large language model like ChatGPT?
They can't. It would be a real problem with confidentiality if they just ran client-related data through one of the public generative AI systems. So they have to either doing two things. They're either creating their own ecosystem, their own system that they will basically then contract with, say, OpenAI, and have the API from ChatGPT brought into their ecosystem so that none of the data leaks out. It's contained within that law firm, and they can then ethically use a client data. Or there's a bunch of off-the-shelf companies that are basically contracting with companies like OpenAI and others to be, custom legal software programs to law firms that are basically self-contained, that can be used without leaking confidential data. So either they're doing their own in-house system that they're building themselves, the more sophisticated law firms, or they're buying leasing an off-the-shelf program from these vendors who are basically trying to be the intermediaries between the large language models and the law firms.
So is your sense that generative AI is just running rampant through the legal industry, or is it more of a gradual process that it's sort of?
It's gradual, and it's checkered. I mean, so some law firms are still taking the position that they're not going to allow their attorneys to use this. They're concerned about the confidentiality. They don't have the advanced systems to basically contain it. And so I know of law firms that basically say, no, you cannot use it, even though I'm sure some of their lawyers are in fact using it. Others are going all in and developing their own custom in-house solutions, or they're contracting with a vendor who provides that to them, and are saying, we're going to be on the cutting edge. We're going to be the ones to save the clients money. That's going to put us in a competitive advantage. I was at a conference a few weeks ago, and we're talking about a law firm that just put out a press release. They're not using generative AI. And I said to my colleague, I said, I've never heard of them. And he says, and you'll never hear of them again. This is a path to doom for a law firm to basically, close their eyes to technology and not try to stay on the cutting edge. It may work for a few months, but it's going to, sink them in the long term.
Okay. Now, another issue, of course, would be what jobs in the legal industry could be impacted by this? I would assume it might be at the junior level.
Yeah, so that's a real problem, is because a lot of things I did as a first or second year associate, and I think most first and second year associates do, is document review and legal research. Those are the tasks that are most quickly automated and are being automated. And so there's less and less for young starting lawyers to do without a lot of training. So that really creates a dilemma. It turns out that, fourth and fifth year associates are in huge demand because law firms want them, not first or second years. But you can't get fourth or fifth years if you don't go through first and second year. So there's a lot of dynamic pressures going on in the industry, sort of the models of developing associates. I also think it puts more burden on our law schools to basically create practice-ready lawyers who can step in and do things other than legal research and document review, who have some of the capabilities and knowledge to do some of these higher-end tasks that won't be replaced by AI anytime soon. So that's where I think law schools are have this duty really to sort of shift how we are training our law students to make them more able to compete in this marketplace.
In other words, they can hit the ground running at the
Yes.
what would now be the third or fourth year of,
Exactly.
Yeah, I see.
Yeah.
Interesting. So what are some other either positive or negative impacts that come to mind on the practice of law as you see it of generative AI?
So I think there'll generally be a reduction in the number of people practicing law, Goldman Sachs study estimated 44% reduction. I don't know if it'll be that severe, but there's no question there's going to be somewhat of a reduction in the number of lawyers who are able to practice law. And that therefore, puts this increased pressure on them to be the ones who can succeed. And I think being technically proficient will be a key factor in that. So there's that. There's all kinds of ethical issues in terms of, how do they deal with their clients on this? When I was a practicing lawyer, if I wanted to use WordPerfect or Word, I didn't have to ask my client. But now if you're talking about using AI or not using AI, or which system of AI you're going to use, that's going to create this greater need, I think, to consult your client and have more of an agreement on what you're going to do. We've already seen one case where a judge called out the lawyers in front of their client and said, hey, you're applying for your legal fees to be covered because you won the case. You're entitled to that, but you should have only spent a third amount of time on this that you did, because if you had used AI, it would have cost a third as much. And so you can imagine how embarrassing that was for the lawyers to have used AI, but instead use human labor. So again, the question of, which are the tasks that humans can do best, which are the tasks that machines can do best. And then I think there's also a lot of pressure on attorneys to oversee the AI system and make sure it's not missing things, because these systems are by no means perfect. They miss things, they lack true understanding, so they can miss subtle points or incorrect points or hallucinate with incorrect stuff. So attorneys who are not supervising their AI systems outputs before it's being presented to a court or a client or whatever are really at risk, I think, of malpractice. So I think there's a lot of new responsibilities for an attorney in this new world.
Man, yeah, as you say, it's a whole new world. Now, on the laws themselves, whole new case laws will come out of AI, generative AI related, culpability, liability. You brought up some fascinating examples of, for example, a robot who actually killed a factory worker on the assembly line. Do I have that right?
Yes, I was at a Volkswagen plant in Germany, and these robots were working with the workers in the same space, seemed very safely. And then one day, one for unknown reasons just reached out and squashed the head of one of the human workers and killed him. And the prosecutors spent 2 years trying to figure out who was responsible for this. And in the end concluded no human had the intent, which is what's needed in a criminal case, and what's called mens rea, an intent to commit the crime. No human had that. It wasn't the developer or the manufacturer of the robot. It wasn't the factory owners. It wasn't the foreman. Nobody had the requisite intent for a criminal act, even though this seemed to be a criminal act. And we're seeing this in a number of areas where acts are done with machine learning systems making the decision, and no human is responsible for it under existing legal doctrines.
So that's criminal. Was there a civil case then?
Yeah, there's civil cases similarly. There's some of the autonomous vehicle cases where an autonomous vehicle is involved in a crash. Who is the responsible party? Did they have the foresight? You have to be able to foresee something in order to be civilly liable for something. If it wasn't something you could anticipate under longstanding doctrine, you're not responsible for it. So again, there's the issue of, was it foreseeable when the machine goes off and does its own thing? Who is a responsible party? Is it the manufacturer? Is it the software developer or programmer? Is it the company that implements or deploys the technology? Component manufacturers? There's now multiple possible parties you could point the finger at, but basically none of them foresaw this happening, and so technically aren't subject to civil liability. So this is again going to require the law to somehow evolve to this to make sure that there is some oversight. We also see in the autonomous vehicle, what do we expect of these technologies in terms of the standard? And so I gave the example of a GM car, a cruise car in San Francisco, where a motorcyclist was driving recklessly and crashed into the back of the GM car, and even though the police report said the motorcyclist was 100% responsible for the accident, he ended up suing General Motors and said, because your car has all these great capabilities, you should be able to see 360 degrees at all times. You should have seen me driving recklessly and moved out of the way. And so, what is the responsibility of these autonomous machines in terms of the standard we'd expect? It seems like it's much higher than if it was a human driver. but how much higher? And how are these companies supposed to know where the line is going to be drawn? Nobody knows at this point.
And as I recall, GM settled that suit. They didn't
Yeah.
contest it.
They didn't want to go to a jury. I mean, juries don't like exotic technologies. The idea of a machine killing someone or hurting someone, no company wants to be necessarily going in front of a jury with that. So they settled, even though they weren't at fault, clearly.
Now, there was also a case you brought up of a large language model inventing out of whole cloth a sexual harassment suit. Could you talk about that
Yeah,
case?
so this was a law professor that a website used ChatGPT to generate some content, including a claim that this law professor sexually harassed law students on a way to a field trip to Alaska. It turned out this professor's never been to Alaska. There was no such claim. It was just made out of whole cloth. Who knows how this machine, the ChatGPT, came up with this scenario, but we know it comes up with just far-fetched sort of hallucinations sometimes. And so this, is damaging to that professor's reputation because he can deny it. But once it's out there, that could be still an ongoing harm. People start to think that he may have been involved, And so, it's not clear if he's going to file a lawsuit yet, but some other lawsuits have been filed by people who have been defamed, they argue, by a ChatGPT or other large language model of wholly creating, a false allegation. And so, how these get resolved is really open issue right now, because there is this Section 230, the Communications Decency Act, going back to 1986, 1996, that allowed the internet to flourish by saying a platform is not liable for content that other people put up there. So when you have a ChatGPT system, who is creating the content? Is it the person who submits the prompt and asks the question, or is it the ChatGPT that gives the answer? If it's the latter, then they can be liable for things like defamation. But if it's the former, they aren't. So Google is not liable if a search says something defamatory, because they're being prompted by the user. That's the user is dictating this. I think with large language models, it's a much closer case. And so we got cases pending now, and it'll be decisions of first instance to sort of try to figure out, how does this statutory provision that was written without anticipating AI apply to this AI context?
Well, that's going to require the efforts of some very wise juries and judges.
Yes, absolutely. And I must have, I think, 10 talks the rest of this fall to judicial groups about AI, because they see this coming and they're looking for guidance and how they should deal with this.
Yeah. Now, if the head of a law firm takes to heart the statement, we either go to large language models or you won't survive. What do you have thoughts on first steps that a typical law firm should take? I mean, should they immediately hire a data scientist, or should they move toward maybe a prepackaged kind of solution to get them going? What would be a logical first steps?
So a number of law firms and courts in the last couple of years have hired an in-house data scientist and have reported it's incredibly valuable, much greater than they actually anticipated, as many lawyers in the firm turn out to rely on that data scientist for all kinds of projects and uses. So this turns out to be quite a useful investment to have that in-house expertise there with at least one person who's not a lawyer, but rather a data scientist, maybe who has some understanding of law. So I think that is a great idea for a larger firm. For a 5 or 10 person firm, is probably not feasible. But I think, they should start creating training programs. And there's all kinds of people out there now offering training for lawyers and law firms on AI. And they could either use some in-house expertise or bring in some of these outside consultants to start training their lawyers. Lawyers are smart people. And so I find, for example, with law students, I've been working on AI for 10 years. Many of these law students know way more than I do. They're using all kinds of things I've never used and doing all kinds of things. So, lawyers are smart people. And if you give them the opportunity, they can be very innovative and figure out ways to use these various technologies in ways, no one might have thought of.
And speaking of that, Gary, if you could give us a little bit of your background, how did you get into this AI and the law area of focus, and what has been your experience in it?
So I had a PhD in genetics, and I went into law school to do genetics in the law. And I came to Arizona State because it had this big program in law and technology. And I ended up taking the lead on that program after the previous director passed away, unfortunately. So I've been running this program for 20 years, and we deal with sort of any emerging technology that comes along. And obviously AI was on the drawing board for the future. I got asked to be a co-PI of a large grant given up by the Future of Life Institute, funded by Elon Musk, on super intelligence or artificial general intelligence, and how do we prevent it from destroying the world. And this group had a lot of top AI experts on it from academia and industry and the military and so on. And so I got to go to those meetings and really learn a lot of the terminology and techniques and technologies involved. It was all sort of new to me, but I sort of then leveraged that to work on a number of other projects and grants and teaching a course. I've been teaching a course on AI in the law for 5 years. And, even though I have no computer science background, I've picked up enough of it to be able to understand most of the legal issues, even though some of the technology is beyond my ability to understand sometimes. But I think that's true of everybody, right? Even people in technology, they're swimming, trying to keep up with all these developments. It's so hard to keep on top of it.
It's a struggle for sure.
Yeah.
Okay, we've been with Gary Marchant, Arizona State University Law School professor. Thanks very much.